Swayam Prabha. Digital India. Educated India.
Hello everyone, this is lecture number 19 where I am dealing with hazardous and other waste. I am Dr. Shabnam Melawat, an Associate Professor from the Faculty of Law, University of Delhi. I will be informing you about the various waste rules which relate to hazardous waste which have been applied in India as a part of our consonance with the international environmental law. What is hazardous waste? It is simply defined that hazardous waste is a waste with properties that make it dangerous or capable of having a harmful effect on human health or environment. Hazardous waste is generated from many sources. It ranges from industrial manufacturing processes waste to batteries and may come in many forms including liquids, solids, gases and the sludges. Rapid industrialization in last few decades have led to the deployment of natural resources and increase in pollution in the country. As a part of that economic development, the industrialization has led to generation of huge quantities of hazardous waste causing severe environmental problems. Hazardous wastes are generated because of the following reasons: use of hazardous substances, use of inappropriate technologies, end of pipe treatment of effluents or emissions. The Ministry of Environment and Forests and Climate Change, formerly known as the Ministry of Environment and Forests, promulgated Hazardous Waste Management and Handling Rules 1989 under the provision and aegis of the Environmental Protection Act of 1986. The Environmental Protection Act of 1986 has a provision which empowers our central government to make rules with respect to specific problems wherever they might be there, and it also empowers the state government to make rules with respect to the state if they are for the purpose of protection of environment. In September 2008, the said rules were amended and new rules entitled Hazardous Waste Management, Handling and Transboundary Rules 2008 were promulgated. These rules were further amended in the year 2009 and 10 for proper management and handling of hazardous waste in our country. India has ratified the Basel Convention on Transboundary Movement of Hazardous Waste in the year 1992 and is a signatory to the convention. It is an international treaty that was designed to reduce the movement of hazardous waste between nations, except where it is perceived to be in accordance with the principles of environmentally sound management. The rules have been amended recently, entitled Hazardous and Other Waste Management and Transboundary Movement Rules 2016, to include other waste such as waste tire, paper waste, metal scrap, used electronic items, etc. About 83% of the total hazardous waste is generated from 6 states. These six states are Gujarat, Maharashtra, Tamil Nadu, Andhra Pradesh, West Bengal and Chhattisgarh. There are about 29 common secured landfill facilities in 16 states and 14 common incinerators in 7 states in order to manage the hazardous waste in environmentally sound manner. As per the Compendium of the Environmental Statistics India 2016, about 90% of the total hazardous waste generated in the country is being contributed by 10 states, and out of these, the industries in 3 states of Maharashtra, Gujarat and Andhra Pradesh contribute about 60% of the total hazardous waste. Most of the waste is being generated from chemical production and metal processing industries, apart from the treatment of wastewater and flue gases. The chemicals and hazardous waste. Humans are exposed to chemicals every day through their multiple routes but are not limited to ingestion, eating or swallowing, inhalation, skin contact and via the umbilical cord of the unborn child. It can be clearly stated that not all chemical substances are harmful, and a number of them are used for individuals and families across the globe on a daily basis with little or no side effects. Some of which are common salt or the sodium chloride, baking powder, sodium bicarbonate, detergent, sodium sulfate, mouthwash, hydrogen peroxide, aspirin, acetyl salicylic acid. However, there are some other chemicals and chemical substances that people get exposed to in their day-to-day lives that can be very highly hazardous, and they pose negative effects to our health and environment when properly managed. Data released by the World Health Organization reflects that nearly 1.6 million lives and 45 million disability adjusted life years were lost in 2016 due to exposures to selected chemicals. Besides the adverse effects of chemical substances on human health, the environment and the ecosystem may also be deeply impacted through the long-term exposure of certain chemicals or short-term exposure of highly lethal and toxic chemicals released into the water, air or land. That is why chemical waste is categorized as hazardous owing to their chemical reactivity, toxicity, explosiveness, corrosiveness, radioactivity or other characteristics that constitute a risk to human health or the environment. Then there is the health hazard, acute toxicity. Acute toxicity refers to serious adverse effects or lethally after oral, dermal or inhalation of gases, vapors, dust or mist exposure of a substance or mixture. The skin corrosion irritation is the production of irreversible damage to the skin. Serious eye damages and irritation. Serious eye damage is the production of tissue damage in the eye or serious physical decay of the vision, not fully reversible, that occurs after exposure of the eye to any substance or mixture. The respiratory or skin sensitization. A respiratory sensitizer is a substance that will induce hypersensitivity of the airways following inhalation of the substance. A skin sensitizer is a substance that will induce an allergic response following skin contact. Reproductive toxicity refers to adverse effects on sexual functioning and fertility in adults, and developmental toxicity in the offspring after exposure to a substance or mixture. Aspiration hazard refers to severe acute effects such as chemical pneumonia, varying degrees of pulmonary injury or death following aspiration of a substance or mixture. Environmental hazards, hazards to the aquatic environment. Acute aquatic toxicity is the intrinsic property of a substance to be injurious to an organism in a short-term exposure to that substance. Chronic aquatic toxicity is potential or actual properties of a substance to cause adverse effects to aquatic organisms during exposures which are determined in relation to the life cycle of the organisms. Hazardous to the ozone layer. The ozone depleting potential is an integrative quantity distinct for each halocarbon source species that represents the extent of ozone depletion in the stratosphere expected from the halocarbon on a mass for mass relative to CFC 11. Interventions of international organizations in the field of chemical and hazardous waste management. Due to a wide range of harmful effects the hazardous waste poses over many years, different international and regional organizations across the globe have taken initiatives to set up frameworks for the proper management, handling and disposal of such waste. The United Nations Environment Programme, which was founded in June 1972 as a result of the United Nations Conference on Human Environment and Development, UNEP has the overall responsibility and accountability for environmental problems among the United Nations agencies. UNEP categorizes its work into 7 broad thematic areas, which are climate change, disasters and conflicts, ecosystem management, environmental governance, chemical and waste, resource efficiency, and environment under review. With regard to management of hazardous waste, UNEP came up with a unique program called the Harmful Substance and Hazardous Waste. The UNEP under its aegis initiated the signing of several international treaties on waste and hazardous waste, including chemical waste, and hosts the Secretariat of Basel Convention, Rotterdam Convention, Stockholm Convention, and the Global Program of Action for the Protection of Marine Environment from Land-Based Activities. One of the major ongoing activities at the UNEP is the Chemical and Products or the CIP program initiated in the year 2008. The United Nations Development Program. The sound management of chemical and waste is an important component of the UNDP's efforts to achieve sustainable, inclusive, and resilient human development and the Sustainable Development Goals. The UNDP advocates for integrating chemical management priorities into national environmental and poverty reduction planning frameworks. It helps countries access financial and technical resources and provides technical assistance and implementation support to improve the holistic management of chemicals and waste at the national, regional, and global levels. UNDP's expertise covers management of chemicals which are harmful to human and environmental health, including persistent organic pollutants, ozone-depleting substances, mercury, lead, and other heavy metals. UNDP helps countries strengthen their waste management systems, including waste prevention, reuse or recycling, treatment, and disposal. The background for international regulation in chemicals and hazardous waste management. In 1982, the UNEP convened a working group of experts to develop principles on the management of hazardous waste. The group developed the Cairo Guidelines for Environmentally Sound Management of Hazardous Waste that contained a number of principles to regulate the transboundary movement of hazardous waste, which were meant to assist governments in arriving at their own waste policies. The 5 conventions namely are the Basel Convention, the Rotterdam Convention, and the Stockholm Convention, the SAICM, and the Minamata Convention, having contributed to the development of a global regulatory framework in the management and disposal of hazardous waste. The Basel Convention on Transboundary Movement of Hazardous Waste and their Disposal in the year 1989 was adopted and entered into force on 5th May 1992. The management of hazardous waste has been on the United Nations agenda ever since the first Montevideo Program on Environmental Law in 1985. The process to develop and implement guidelines regulating the movement of hazardous waste across countries was accelerated after the discovery in the mid-90s that several countries in the developing world, especially Africa, had become the dumping ground for hazardous waste of the developed world. Convention has been amended several times, with a new amendment being proposed in Norway in 2018 that aims to minimize marine pollution by restricting illegal dumping of the plastic waste. The amendment seeks to move plastic waste from Annexure 9 of the Convention to Annexure 2, which would require countries exporting plastic waste to get the informed consent of the importing country. Further, it would create stringent requirements for plastic waste to be considered non-hazardous. The Basel Convention has been subject to criticism regarding its effectiveness in achieving its stated objectives. It was found empirically that the international waste trade has actually increased since the Basel Convention came into force. This convention has seemingly done more to legitimize international waste trade rather than reduce it. The ban amendment introduced in 1995 sought to address these concerns by banning waste trade between countries, mentioning in Annexure 7 of the Convention and countries not mentioned thereof. E-waste has also been a primary concern of the Basel Convention since 2002, when the MPPI or the Mobile Phone Partnership Initiative was formed at the 6th Conference of Parties to the Basel Convention. The MPPI aims to promote the environmentally sound management of end-of-life mobile telephones. In order to achieve this, a guidance document was prepared and finally adopted at the 11th Conference of Parties in 2011. At the 8th meeting of the parties of the conference in 2006, the Nairobi Declaration on Environmentally Sound Management of Electrical and Electronic Waste 12 was adopted. giving the Secretariat of the Basel Convention a formal framework within which to operate on the development of a work plan to manage e-waste in an environmentally sound manner. The Cartagena Declaration 14 was adopted at the 10th Conference of Parties to the Basel Convention in order to put forth a strong commitment by the parties to promote the prevention and minimization of the generation of hazardous and other wastes. This declaration was a culmination by the parties' realization that Basel Convention provisions are inadequate to deal with the issues posed by accumulation of waste, despite having been in force for over 20 years. The declaration aimed to actively promote and implement strategies for prevention and minimization of waste generation, take measures to de-link economic growth from environmental impact, and encourage greater cooperation between parties so as to ensure that there are comprehensive global and regional efforts to improve access to cleaner production processes through capacity building and technology transfers. Now, what is the Basel Convention on Transboundary Movement of Hazardous Waste? It is a convention which aims to protect the environment by bringing measures to control and regulate hazardous and other waste disposals. Negotiation of the convention started in the 1980s under the auspices of the United Nations Environment Programme. Main points of the Basel Convention are: it has come into force in the year 1992. It has its secretariat which is situated in Geneva, Switzerland. It applies prior consent approval procedure to regulate the transboundary movement of hazardous and other wastes. Non-parties cannot transport hazardous waste to and from each other unless specifically agreed. Basel Convention states such transportation illegal. The member nations to the convention are required to have domestic legislations for both prevention and punishment of the illegal trafficking of such hazardous waste. It ensures that the member nations control the generation, storage, transportation, treatment, reuse, recycle, recover, and finally dispose of the hazardous waste. The Conference of Parties, or COP, is the primary organ of the Basel Convention and is responsible to make decisions about the operations of the convention. This COP meeting, it meets biannually. Basel Ban Amendment. The Basel Ban Amendment was adopted in 1995, which added a new Annex 7, and it entered into force in December 2019. It is an agreement under the Basel Convention between the parties to prohibit the member states of the Organization for Economic Cooperation and Development, the European Union and others who have ratified the ban amendment from exporting hazardous waste to other countries, primarily the developing countries or countries with economies in transition. COP14, the COP14 meeting to the Basel Convention has been the latest meeting which took place in April to May 2019, and it brought new entries into the convention which would be effective from 1st January 2021 onwards. COP15 will take place in July 2022 at Geneva, 2024 at Geneva. The Basel Protocol on Liability and Compensation for Damage resulting from transboundary movement of hazardous waste and their disposal has been adopted in 1999 and has yet to come into force. India has yet not signed this protocol. The radioactive waste and waste derived from normal operation of the ships are excluded from the list of hazardous waste of the Basel Convention. The Basel Protocol on Liability and Compensation for Damage resulting from the transboundary movers of hazardous waste and their disposal was adopted by COP5 in 1999. The Basel Convention on the Control of Transboundary Movement of Hazardous Waste, the scope of the convention. The following wastes are subject to transboundary movement and are considered hazardous waste for the purpose of this convention. The waste that belong to any category contained in Annex 1, unless they do not possess any of the characteristics contained in Annex 3, and waste that are not covered by Para A are not defined or considered to be hazardous waste by the domestic legislation of the party of the export, the import or the transit. Wastes that belong to any category contained in Annex 2 are subject to transboundary movement shall be other wastes for the purpose of this convention. Wastes which as a result of being radioactive are subject to other international control systems, including international instruments applying specifically to radioactive materials, and are excluded from the scope of this convention. Wastes which are derived from the normal operation of a ship, discharge of which is covered by another international instrument, are excluded from the scope of this convention. The definition, it provides important definitions. It provides what is a waste, what is management, what is transboundary movement, what is disposal, approved site or facility, a competent authority, the focal point, and environmentally sound management of hazardous waste or other waste, and illegal traffic. These are the important definitions which go to talk about firstly defining what the issue is in the form of a waste, managing that waste in a regulated manner, and when movement of this waste takes place, how to handle, how to ensure that it is disposed of in a safe manner, the approved site or facility where the waste may be stored or taken for the purpose of reuse or recycle, the authority in a country who is a competent authority to deal with it, and sound management. Waste of hazard waste is a very important tool in the hands of a country where it is likely to create less pollution. The convention controls and regulates the following hazardous waste: the used lead acid batteries, biomedical and healthcare waste, the persistent organic pollutant waste of POPs, waste used oils, the polychlorinated biphenyls or PCBs compound for electric transformers and capacitors, heat exchange fluids, additives in paints, sealants, carbonless copy paper and plastic use, the chemicals and pesticides that last for many years in the environment. Industries and other consumers generate chemical waste. The Indian response and compliance to the convention is: India is one of the initial countries to sign and ratify the Basel Convention, which, having ratified the convention on the 22nd September 1992, just over 4 months after it came into force. Considering the inadequacy of the convention's initial provisions to tackle the problem of hazardous waste movement effectively, this did not have much effect on India. Being a developing country, it has become a dumping ground for the waste material of the developed countries and was one of the leading importers of waste materials in the world. The ratification of the Basel Convention had done little to change that. In an attempt to improve their situation, India and a few developing countries came together at the first COP meeting of the Basel Convention and stated that developing nations had to keep their own waste rather than attempt to dump it on the developing country. India continues to maintain its stance at the second conference, sowing the seeds for introduction of the ban amendment to the Basel Convention, which would ban countries which were part of the OECD, that is, developed countries, from moving their waste to the non-OECD countries. Following the introduction of the Basel Convention, India brought a legislation to deal with the hazardous waste, the Hazardous Waste Rules 1989, under the provisions of the Environmental Protection Act 1986. This legislation was found to be lacking in terms of covering the provisions of the convention and was amended several times over the years till it is finally repealed and replaced by the Hazardous Waste Management and Handling Rules 2008. This new legislation too was amended 4 times before it was replaced, and then came the Hazardous Waste Management and Handling Rules 2016, which have been recently amended in 2019. India has brought out a National Hazard Waste Management Strategy in 2017. Then the constitutional law and provisions related to environmental protection are: as per the Stockholm Declaration of 1972, India, being a signatory of international pacts, has an obligation to translate those provisions and follow them in our country. This has been clearly stated under Article 51 subclause C that the state shall foster respect for international law and the obligation of the treaties. Another essential provision deals with protecting the environment is Article 253 of the Constitution, which empowers the Parliament to make laws with respect to the whole or any part of our country for implementing any agreement or convention which is signed with any other country or countries. With the use of this power, it is pertinent to know the Parliament had enacted the Air Prevention and Control of Pollution Act 1986 and the Environmental Protection Act of. It is clearly stated that these acts, that the purpose of the enactment was to implement decisions taken at the United Nations Conference Environment and Development held at Stockholm in the year 1972, or the popularly known convention or the Stockholm Declaration. The Vellore Citizens Welfare Forum case, the Supreme Court held that it is essential to incorporate the international customary laws in the municipal laws provided they are not contrary, and it is an acceptable principle of law. So, it was considered essential to follow international laws by the domestic courts of the law. Article 47 puts an obligation on the state to raise the level of nutrition and standard of living. 48A, it aims to provide for preserving and protecting the environment. Part 4A of the Constitution deals with fundamental duties, with 51AG asking the citizens to protect and improve the natural environment, including the forests, rivers, lakes, wildlife, and having compassion for living creatures. In the case of Kinkari Devi versus State of the Himachal Pradesh High Court held that Section 48A and 51AG are both constitutional pointers to the state and constitutional duty of the citizens not only to protect environment but to improve, preserve and safeguard it. Article 21, which extends the same standard of living and a clean and safe environment, thus asking citizens to protect their fundamental right to life after it has been infringed, is justified. Then comes the Environmental Protection Act. It was enacted under Article 253 of the Constitution. It aims at creating authority, coordinating the activities of various regulating agencies. The task is to create general laws for environmental protection, provide deterrent punishment to those who endanger human environment safety and health, and the main goal is it should be the concept of sustainable development, which is regarded as one of the goals of the Act. Sustainable development includes achieving the object and purpose of the Act as well as protection of life under Article 21. General powers of the central government. It takes measures to protect and improve the environment and give directions under Section 3. The power is vested to take any reasonable and valid steps for the purpose of protection and improvement of environment. It also includes the power to give directions under Section 5. These directions should be made in writing to an officer who is bound to comply with those directions. It also has the power to direct the closure, prohibit or regulation of any industry and its operational processes. The Hazardous and Other Waste Management Rules 2016, they are there to strengthen the implementation of environmentally sound management of hazardous waste. The ministry brought out these rules which were notified by the central government. The rules encourage the reduction of hazardous waste generation and encourage the recycling and reuse process. They also specify strict guidelines for import, export and even storage and transportation of hazardous waste in order to ensure optimum waste management and its disposal. These rules aim to protect the environment at large as well as persons who come in contact with this hazardous waste and are at a higher risk of being exposed to them. The procedure for management of hazardous waste, the responsibility of the occupier for the management of hazardous and other waste. For the purpose of management of waste, an occupier or an industrialist shall follow the following steps, namely prevention, minimization, reuse, recycle, recovery, utilization including co-processing, and the safe disposal of the waste. The safe and environmentally sound management of hazardous and other waste, prevent accidents and limit their consequences on human beings and environment, provide persons with a safe working environment with appropriate training, equipment and information necessary to ensure their safety. responsibilities of the occupier for waste management are, there are important rules which relate to the same. These are responsibilities of the state government for environmentally sound management, grant of authorization for managing waste, the power to suspend, cancel an authorization, the storage of hazardous and other waste, the utilization of hazardous and other waste, the standard operating procedure or guidelines for actual users. The import and export of hazardous waste. Under Rule 11, it is an important provision which talks about the import and export of hazardous waste. The Ministry of Environment and Forests and Climate Change is the nodal ministry where there is a strategy for export and import of hazardous waste. No import of India for disposal shall be permitted. The import shall be permitted only for the purpose of recycling, recovery, reuse and utilization including co-processing. The import in Part A, B of Schedule 3 with the prior informed consent of the exporting country shall require the permission of the Ministry of Environment and Forests. No import of waste specified in Schedule 6 shall be permitted. The import and export of hazardous and other waste not specified in Schedule 3 but exhibiting the hazardous characteristics outlined in Part C of Schedule 3 require prior written permission to be taken from the Ministry of Environment and Forests before it is exported to or imported to or exported from India as the case may be. The procedure for import of hazardous waste. Rule 13, the use of Form 5 is used to enforce certain procedures for the import of hazardous waste. Actual users intending to import or transit for the transboundary movement and other waste specified in Part A and Part B of Schedule 3 should apply in Form 5 to the Ministry of Environment and Forests. But for the import of other waste listed in Part D of Schedule 3, the user has to furnish information in Form 6 along with associated documents to the custom authorities. In addition, if the importer is a trader, then the waste on behalf of actual users should obtain one-time authorization in Form 7 and copy of this authorization should be appended to the Form 6. Requisition forms are submitted. The Ministry of Environment and Forests take upon the comment and suggestions of the Pollution Control Board and which may grant the permission for import within a period of 60 days subject to the positive conditions that importer has, environmentally sound facilities, adequate arrangements for treatment and disposal of the waste, a valid authorization and consent from the State Pollution Control Board, prior informed consent from the exporting country in case of Part A of Schedule 3. Copy of all forms should be handed to the concerned port and custom authorities and the central board and the state pollution control boards to ensure their compliance. The importer of the hazardous waste should maintain records of the hazards and other wastes which are imported under a form, and the records so maintained should be available for inspection. Rule 14 talks about procedure for export of hazardous waste from India. Any occupier intending to export waste specified in Part A of Schedule 3, Part B of Schedule 3 and Part 6 should make an application in Form 5 with an insurance cover to the Ministry of Environment and Forests for the purpose of transboundary movement of waste with the prior informed consent in writing from the importing country in respect of that waste. Upon receiving an application under Sub-Rule 1, the Ministry shall give permission for proposed export within a period of 60 days from the date of submission of complete application and may impose conditions if they are so necessary to do so. The Ministry then shall forward a copy of the permission granted to the State Pollution Control Board of the state where the waste is generated and the board of the state where the port of export is located and the concerned port and custom authorities for ensuring compliance of the conditions of the export permission. Exporter should ensure that no consignment is shipped before the prior informed consent is received from the importing country wherever it is applicable. Exporter should also ensure that the shipment is accompanied with movement with the documents. It should also maintain the records of the hazardous waste and the records so maintained should be available for inspection. Rule 15. The illegal traffic. Export and import of waste respectively shall be deemed to be illegal if it is without the permission of the central government in accordance with the rule. The permission has been obtained through falsification or a misrepresentation or fraud. It does not conform to the shipping details provided in the movement documents. It results in deliberate disposal, that is dumping of waste in contravention of the Basel Convention and of the general principles of international or domestic laws. The treatment, storage and disposal facility of hazardous and other wastes, the state government occupier, operator or any other association of occupiers should individually, jointly or severally be responsible for identification of sites, for establishing a facility for treatment, storage and disposal. Operator of the common facility or occupier of a captive facility should design and set up the treatment, storage and disposal as per the technical guidelines issued by the Central Pollution Control Board in this regard from time to time, and obtain the approval from the State Pollution Control Board for design and layout in this regard. The State Board will be monitoring the setting up and operation of the common or captive treatment, storage and disposal regularly. Operator of the common facility or the occupier should be responsible for safe and environmentally sound operation of the facility and its closure and post-closure phase as per guidelines or standard operating procedures issued by the CPCB from time to time. The operator or occupier should maintain records of hazardous and other wastes handled by him in a proper manner prescribed. Operator of the facility should file an annual return in Form 4 to the SPCB before June 13th following the financial year in which that return relates. The packaging, labeling and transport of hazardous waste. It is mandatory to package and label the same when the movement of this waste takes place. The occupier handling hazardous or other waste and operator of the treatment, storage and disposal facility should ensure that the hazardous wastes are packaged in a manner suitable for safe handling, storage and transport as per the guidelines issued by the CPCB from time to time. With regards to the transport of this hazardous and other waste, it should be in accordance with the provisions of these rules and the rules made by the central government under the Motor Vehicles Act 1988 and the guidelines issued by the central board from time to time in this regard. The occupier should provide the transporter with the relevant information in a required form regarding the hazardous nature of the waste, the measures to be taken in case of emergency, and should also place labels on them on the containers that these containers contain hazardous waste. Whereas in case of transportation of hazardous and other waste for recycling or utilizing including co-processing, the sender should intimate both the SPCB before handling other waste to the transporter. Now this is a manifest system where the document for hazardous waste is to be used within the country only. There are color codes details of manifestation and its corresponding purpose. A few of them have been given by me. The copy number with color code white, it is to be forwarded by the sender to the SPCB after signing of 7 copies. The yellow code is to be retained by the sender after taking signatures from the transporters and the rest of the signed copies to the transporter. Copy number 3 contains a pink color code which is to be retained by the receiver of the actual disposal facility operator. After the carried out by or treatment, storage and receiving the waste, and the remaining copies are to be duly signed by the receiver. Orange color represents to be handed over to the transporter by the receiver after accepting waste. The green color indicates to be sent by the receiver to the State Pollution Control Board. The blue represents to be sent by the receiver to the sender, and grey represents to be sent by the receiver to the SPCB of the sender in case the sender is in another state. Miscellaneous. Under Rule 19, records and returns maintenance are to be done. The occupier handling hazardous or other waste and operator of disposal facility shall maintain records of such operations in a specified form called Form 3. The occupier handling hazardous and other waste and operator of the disposal facility shall send annual returns to the SPCB in another form. The SPCB then shall prepare an inventory of hazardous waste generators, actual users, and common and captive disposal facilities and shall submit the information to the Central Pollution Control Board every 2 years. The Central Pollution Control Board shall prepare a consolidated review report on the management of such waste and forward it to the Ministry of Environment and Forests along with its recommendations before December 30th once in every year. Accident reporting. Any accident that occurs at the facility of the occupier handling hazardous waste or other waste and operator of the disposal facility or during transportation. The occupier, the operator or the transporter shall immediately intimate the Pollution Control Board by telephone or by email or by sending a report in the prescribed manner in Form 11. Rule 23. The liability of the occupier, importer or exporter and operator of a disposal facility. The occupier, importer or exporter and operator of the disposal facility shall be liable for all damages caused to the environment or third party due to improper handling and management of hazardous and other waste. The occupier and the operator of the disposal facility shall be liable to pay financial penalties as levied for violation of the provisions under the rules by the State Pollution Control Board with the prior approval of the Central Pollution Control Board. Then we come down to the cases which have covered a few instances of hazardous waste or related thereof. One of the main cases is that of Research Foundation for Science Appellants Technology National Resource Policy versus Union of India and others. The Supreme Court constituted a monitoring committee comprising of the aforesaid members as also Dr. Claude Alvarez, NGO and Dr. D.B. Boralkar. The committee was to oversee the direction of the court as implemented timely. It would also oversee the aspects to which ministry has agreed are implemented in letter and spirit and without any laxity or delay in the matter. It would be open to the monitoring committee to co-opt a representative of the state government or state pollution control boards or any other person or authority as the committee may deem fit and proper. The monitoring committee shall file quarterly reports in the court. In regard to import of sludge oil under Marpol Convention, the Supreme Court directed the central government to file an affidavit within 3 weeks indicating in detail how the said oil is dealt with after import. It also needs to be clarified in the affidavit whether such oil can, in the perception of the central government, be imported or is only a technical import at the time of discharge of oil as suggested in the affidavit of Mr. Subba Rao dated 14 January 2003. This aspect, including case of import by Daya lubricant, would be considered after filing of affidavit by the central government. In the above background, in addition to directions which I have given, Supreme Court issued the following directions. It defined the role of the State Pollution Control Board. It directed that all the state boards, the PCCs, to implement the directions that may be issued by the Ministry of Environment and Forests. They are directed to produce a comprehensive report on illegal hazardous waste dump sites in their jurisdiction. Reports should be based on inspection, assessment of the size of the dump site, age, whether the dump site is passive or active, whether any precautions have been taken to prevent damage to the environment. The board will also take samples of the groundwater in the vicinity of the dump site at different points and prepare a report on contamination of the groundwater, if any, and if so, to what extent. The SPCBs are directed to draw plans with financial estimates for immediate measures that may be required to stop environmental damage. A full rehabilitation plan should also be prepared together with the estimate costs undertaken. All these reports together would be sent to the Central Pollution Control Board for the board to take necessary action. It defined the role of the central board, that it will be for a period of 2 years would be empowered to monitor the import of hazardous waste, which means it would be empowered to undertake random checks from time to time as a safeguard. It will collate the data from the state boards directly from each board and will randomly cross-check the data up to 10% of the units prior to preparing the national inventory. The central board be directed to repeat the procedure for listing of illegal hazardous waste dump sites in the country. The central board is directed to study the state board reports, make an evaluation of the proposals, counter-check the data generated in the reports, and produce a national plan for rehabilitation of hazardous waste dump sites. Such a plan should be submitted to the court within 4 months. The testing procedure and criteria evolved or which may be evolved by the central board shall be followed by the concerned laboratories. Publication of toxic inventory and community participation, location of industrial sites and secure landfills, national policy documents on hazardous waste. The next case is that of Rajiv Narayan and another applicant versus Union of India and others. According to the applicant, it was noticed that small and big industries were emitting black smoke in the area, which was causing air pollution and health hazards to the local residents. The Ministry of Environment and Forests imposed a suspension or consideration of projects for environmental clearance, which were located in a critically polluted area industrial cluster identified by the central board. The polluted areas identified by the board was in Ghaziabad, and consequently this moratorium became applicable to that city. The applicant prayed for issuance of various orders including closing of the polluting industries, strict implementation of prescribed standards, and ensuring a complete implementation of the action plan for improving air quality within the scope and ambit of the Act, specified in Schedule 1 of the NGT Act. The Joint Inspection Team was directed to inspect the unit and submit its final report to the tribunal, clearly stating whether the industry was complying all the directions issued by the boards and was a non-polluting industry. The Joint Inspection Team should clearly report as to the quantum of extraction of groundwater by the industry, the cess payable and the amount of cess actually paid by the industry for all these years. It should also be placed on record whether the industry has obtained permission from the Central Groundwater Authority for extraction of groundwater, if so with effect from what date. The Joint Inspection Team would also verify if the units have authorization to deal with the hazardous waste and if the same was found in the premises of the unit. The industry was to show as to why it should not be directed to pay compensation for polluting the environment and its resolution for the period when it operated without the consent of the board and admittedly caused pollution as it had not installed proper anti-pollution devices to control and check air and water pollution. The Uttar Pradesh Pollution Control Board and the competent authority under the Water Prevention and Control of Pollution Cess Act 1977 were directed to issue notice to all the industries, particularly industries like MS Rathi Steel, wherever they were extracting groundwater and were not paying appropriate cess in accordance with the Water Cess Act of 1977. If such industry was causing any pollution by their activity, they should be given show cause notice, and these shall be issued by the board within 2 weeks from the date of this order, and it should proceed with such industries in accordance with the law. So these cases go on to show that our courts are very active in creating opportunities, protecting the environment, and implementing the laws and policies both which are international as well as domestic. We have brought our rules and regulations in place for the transboundary movement of hazardous waste. It is for the government agencies and for the people to work collectively to ensure that hazardous waste does not get dumped. When the movement takes place, it should be done in an appropriate manner so as to not cause alarm, damage or any other negative impact on the people and the environment. The courts are very much active in taking in their role for the protection of environment, specifically in relation to hazardous waste, since this waste is very detrimental and it poses grave dangers for all life which is located in and around these places. Even in the capital city of Delhi, there are 2 dumping sites which are there, where the tribunal ordered for the removal of all the dump which has been created. There are mountains and mountains of waste which they said could not be treated or transported in any other place, where then the Supreme Court gave directions for removal of the waste by whatever means necessary. As a result, in one of the dumping sites, fire took place and air pollution which was created in that area went beyond imagination. The people who are living in and around these areas complain of health issues and also other damages which accompany living in and around these areas. So, we have a law in place. We try to implement the law and the rules and regulations which are brought into force, but it is done in a manner, the practical aspect remains to be seen how far it would be successful now and in the future. Thank you.
Hi, I'm Chitwan Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP, you have your incidence of high BP, MAP and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol and incidence of high cholesterol. Now before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So, the WHO went with a 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data, so I will be doing it according to age, by gender and by your weight. So apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors, like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday. So approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So data was converted and provided to the users, that is us, from the UK Data Health Survey. So the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a woman's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol like total cholesterol, good cholesterol and your incidence of getting high cholesterol. Now after this, we went in for a policy implication, and in the policy implication we tried to find 2 policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So, an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health, on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has a impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators, and it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day, but fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.